Thank you so much for joining us. My name is Kimani Woods, and I'm the Communications Manager here at Timewise Financial. We are so excited to be hosting this webinar with Mike today to be talking about trust in estates, education for our clients, and offering free education is something that is really important to us. And Mike happens to be a partner with us in dealing with trust and with estates, and our clients have had wonderful experiences working with him. So we know that he is a wealth of knowledge when it comes to this, and we're so excited to be able to tap into it here today. So you guys will have the opportunity to ask questions throughout the webinar. You'll just do it down at the bottom of your screen. You're going to see a little Q&A section. And so you can click on that and you can ask whatever question that you want whenever, and we will get to them and trying to address as many as we can at the end. So Matt Atwood is a CFP here at Timewise, and you can go ahead and get started.
Awesome. Thanks so much, Kimani. As Kimani stated, I'm a certified financial planner here with Timewise, and I know some of your attendees might have saw it online and be existing clients or just came here to learn more about estate planning. But we at Timewise take a comprehensive approach to all of our clients' financial plans. So not only do we make sure that their portfolios are set up to help them excel, and that they have enough money to retire inspired and enough cash flow to live off of. We also help with tax planning. And one area we'd like to focus on is estate planning. So we know enough to know when there's a problem. We can look at a client's existing estate plan and know if there's some shortcomings, but we work with people like Mike at Cornerstone to help get that problem solved. So Mike, why don't you tell us a little bit about Cornerstone and yourself?
Well, thank you, Matt. I appreciate that. I've been involved with estate planning for about 16 years. And we started Cornerstone because there's not a lot of people that do pure estate planning. There's financial planners and there's stockbrokers and different type of people. But we wanted to focus on a universal need, which was how do we keep private business private? How do we keep the government out of our family business? And so we put together Cornerstone to be able to help people do that. And it's been a great ride for the last 16 years doing this. We've had some great relationships that we've built, and I think we've saved a lot of people and a lot of families a lot of aggravation.
Awesome. Well, let's jump right in. So I know trusts and estate planning can generate a lot of mystique. It can sound very intimidating to a lot of people, and they might have that uncle at the family reunion who talks about his single shot trust or something crazy, but they never know like exactly what it is and if it's fitting for them. So why don't we start by you just explaining to us exactly what is a trust?
Well, a trust, very simply in its basic form, is a legal entity that you form while you're alive and healthy. You then retitle your assets into the trust, and the trust becomes the owner of all your stuff, and you own the trust. Now, there's no disadvantage to this while you're alive. If you want to buy something, you buy it. If you want to sell something, you sell it. What the trust does is it protects all of the assets, so that when you pass away, or in a husband-wife situation, when the second one passes away, all of those assets flow through the trust to the children without the need for probate, which is one of the big advantages. A lot of people don't understand, if all they have is just a will, that will has got to go through a governmental process called probate when the second person passes away. And that can be a long and frustrating process. It can be time consuming. It can cost money. There can be a lot of nightmare situations. So we just feel like avoiding all of that probably makes sense.
Yeah, I've seen examples with clients where 3 years later, they're still debating through the probate process, and having it spelled out would have definitely prevented a lot of that. That being said, I think when people hear trusts, they think of like a trust fund kid who's on a boat in the middle of Monaco living off his grandparents' money, or an ultra rich family like the Waltons of Walmart who have this huge estate that they need to parcel out effectively. But I've got a couple scenarios here of the typical demographic of a lot of clients that we work with. I want you to tell me, one, if each of them need a trust or it would be appropriate for them to have, and why exactly. So we work with a lot of young couples. And so the example I laid out here is a young couple that has a house that they purchased with 2 kids and 10 grand in investments. Or we work with a lot of retirees. So let's say you're a retiree, you don't have any kids. You want to leave all your money to, Children's Healthcare of Atlanta or ASPCA, and you've got around $300,000 in investments. And then the last scenario is just an older couple. Their kids are grown, financially independent, thriving on their own, but they've got 500,000 in investments and a home. Would a trust be appropriate for any of those people, all of them, and why?
It's a great question. It's multi-layered. So let me backtrack a little bit and say, in Georgia, just like any other state, you have to have some type of end of life document. So it either has to be a will or it has to be a trust. And typically, wills are pretty simple to do. Any decent attorney can put a will together. You're not looking at a lot of money, probably under $1,000, to be able to do a will for a husband and wife with powers of attorney, et cetera, et cetera, et cetera. The problem with that will is when the second person passes away and now it becomes multi-generational, we've got to go through the probate process to get whatever the assets are. And I think that's the big fallacy is that you have to have a lot to justify having a trust. And what I found out over 16 years is that it's not rich people necessarily that have trusts. It's educated people that have trusts, because if we have to have some kind of an estate plan, if we have to deal with this sooner or later, it makes more sense to deal with it now so that our kids aren't stuck in the middle of this. So going back to your original question, I think all three of those scenarios would benefit from having a trust, because the downside of a trust, if you will, is that it costs you a little bit of money to get it all set up in the beginning. But when you pass, there's no money typically that your heirs have got to spend. And so, if you were to price it in Georgia or Florida or Tennessee or North Carolina, you'd see people spending anywhere from $4,000 to $6,000 to do a trust. So some people go, well, that's too much. That's too much money. Never mind that they may spend twice that ultimately in probate. Not to mention all of the tough times for children having to shepherd that through that system.
Yeah, no doubt. I can say on 2 things you just said there. So one, I know when a loved one passes, you have this hole in your heart. You need the time to grieve and, just take the time to realize that you now have this absence in your life. And it can be a challenge to also be heading down to the courthouse to get assets probated by a judge, or calling all these different institutions to make sure that the assets go in accordance to your family members' wishes. And one thing I like about the clients that we have that worked with you is essentially they're handing whoever their heir is a binder with a card of who to call. And not only are you taking a lot of the burden off the clients who are setting up the trust, but then upon their passing, we are able to take a lot of the burden off of their heirs and make sure they're able to just take the time to grieve. And we have a full accounting of all of the different parts that they had in place and where they wanted each of those assets to go. And we're able to help, as you said, shepherd those different accounts exactly to where the person who passed wished. That being said, also with the price, we've worked prior to meeting you, and we've been working together for a few years now. But prior to that, we had worked with other local attorneys, and it was nothing to see for a simple scenario, a house and a couple investment accounts. a price quoted of $5,000. And you guys come in at near half the price. And from our experience, with more than twice the service, you guys have actually went and driven to our clients' houses and spoken through these different issues in the privacy of their own home. And so we're really fortunate to have met you in the first place. And I haven't had a single negative feedback from any of the clients that have worked with you. It's been all positive, and I think that's because of how far above and beyond you go relative to the other people that are trying to do what you do.
Well, I think, and I thank you for that. We really want to exceed expectations. We try to be excellent in everything that we do. And what's kind of unique is every family is different. We all have some universal things. We love our kids. We want to, make sure that things are done right, and all this kind of stuff. But until I can look somebody in the face at their dining room table and hear from them, and of course, everything we talk about is private. But when people say, well, we have this situation going on, or we have that situation going on, oftentimes they're reluctant to talk about that. But I think we're able to say, tell us the truth, because we're trying to make sure that we don't have nightmare situations for your family down the road. And I think they really appreciate that.
Awesome. With that being said, who doesn't need a trust? You've kind of highlighted how a trust could help someone with some assets and a house. Where would be a situation where maybe just a will is appropriate?
Well, let me say this too, and I'm not an attorney myself. I work with dozens of attorneys, and we do the estate planning, and we send it to the attorney to do the legal work. So I'm just going to give some general knowledge, but don't take this as legal advice. If you decide you want to talk to us, we'll put you in touch with an attorney. But typically, the people that don't probably need a trust would be somebody that maybe doesn't own a home. They don't own any real estate. Their estate is worth less than $10,000 in Georgia. Georgia's got some processes in place that are kind of like small estate affidavits, where you can go down to the courthouse if there's no real estate involved, and if the estate monetarily is worth less than a certain amount. And by the way, all states have some form or fashion of this, and they can deal with that. Those are the people that probably don't need one. But I'll give you even a caveat on that, and that is, let's say you had you didn't own a home, but you worked in an industry, and let's say you got mesothelioma and you passed away, or you were in an accident that was somebody else's fault and you passed away. And in either of those situations, you receive some type of judgment from the court. Let's say you got $1 million or $500,000. Well, now that goes through your estate, and then the estate now has got to deal with that. So some attorneys would say, depending on what your circumstances in, I'm always reluctant to say nobody could benefit from having this. I think all people should be able to look at it, and upon the advice of an attorney, say this would benefit you, or this would benefit you. And again, I think Timewise and Cornerstone, we don't have a dog in that fight. I mean, I think our goal is, let's make sure you have something in writing, because the state of Georgia doesn't recognize oral wishes, right? Let's make sure you have something in writing that says what you want done when that time comes. So I think to that end, everybody should have that hard conversation. And sometimes it's easier doing that at your dining room table.
Yeah, and one thing, just to add some clarity, because I've been asked that before when, recommending you to some of our clients is, so is Mike the attorney? Is he the guy who draws it up? But the real value, I think, to you and Cornerstone is no, you aren't an attorney, but you've built relationships all across the country. So if you have a client or a family member in a different state, you've got a connection there with some of the best attorneys. And at the same time, a lot of these attorneys, 4 or 5 grand, they'll draw up a trust and just say, here you go, we're done. And you actually go to the client, help them get a full accounting of all of their assets, explain exactly what each section means. And then once that trust is delivered, you then go and help them get everything transferred into the name of the trust. So that's where I say the service is enhanced relative to just the attorneys who draw up the paperwork, is because I'm sure you've encountered in your 16 years times where people drew up an exceptional trust with an attorney, but then nothing was in it. Do you have any stories about that?
Well, I actually do. And you're right. We work pretty much nationwide, and I've got attorneys everywhere. And I mean, it's not magic. I've convinced these attorneys to charge less so that we can do the service work. And one of the issues that most people don't understand is attorneys are not in the service industry. They're in the legal document producing industry, right? So they don't want to do service, and they're more than happy to hand off the administrative or service work to us. And this is really where we make a living providing superior service to our people. But I'll give you a great example of that. I do seminars all over the country, and I was in Orlando, and a lady attended my seminar. Actually, she worked for Disney, and she was a musician at Disney. And she sat through the whole seminar, and I always give people the opportunity to meet with me privately afterwards. And she met with me privately. I went over to her house, and she had a trust that was done a number of years ago in a binder, and it was well done. I mean, you could tell the attorney knew what he was talking about, because I've looked at thousands. And she paid $6,800 for this binder. And I want to say it was like 12, 14 years old. Turns out not a thing was funded into the trust. In other words, her real estate, any assets, it was like having a safe that she bought and never putting anything in it. So the safe wasn't protecting anything, right? So she said, we spent $6,800 to do this. And by this time, they had a number of changes that they needed to update. So we were able to charge her less than half of what she had paid and redo it. But this time, we helped her get everything into the trust. And she was so grateful. And that story, I could tell dozens and dozens of dozens just like that.
Awesome. Well, I'm glad you're able to help her out. So I know a lot of clients, they went to an attorney or, LegalZoom or one of these websites and gotten a will, a power of attorney, designating who they want to be in charge of their affairs that they're unable to, and even an advanced medical directive spelling out what they want to happen if they are medically incapacitated. So they may feel like I've got my bases covered. What are some of the pitfalls of just having those 3 documents that a trust actually takes care of?
Well, that's a great question, and this is going to get into a little more complexity, but there's nothing on the books right now that a vendor or the government or somebody would have to accept a power of attorney. We see situations all the time where a bank will say, we don't recognize that power of attorney, or the VA, we don't recognize that power of attorney. So they do it as a courtesy. Well, when you do a comprehensive estate plan, one of the other things that you do is you grant guardianship of yourself to another person. So for instance, in my situation, my wife is my guardian and I'm hers. And let me tell you, she had to think long and hard about making me her guardian. So, but long story short, we wanted to keep that between us. And courts are obligated to accept guardianship. So if I can't communicate, my wife is not only my power of attorney, my durable power of attorney, my medical power, she's also my legal guardian. And that's a huge distinction. And a lot of people don't understand that. And I think what people have to understand, and this is just reality, is that the time to fix all of this, or at least to have the conversation, is now, while you're alive and healthy. Because the problem is that once you find yourself in that situation, it's too late. In other words, if I have done service work for documents for attorneys for people up to and including in hospital rooms where people are, days, if not hours away from passing. And I can tell you that's horrific. I have been in situations where it was a nightmare. And I urge anybody listening, don't wait. Have the conversation now, because we can kind of understand some things. We might even be able to laugh about some things. But when it gets to that point, there's no laughing matter. And so what I tell everybody is you can't fix it after the fact. So you may think you know everything about this, but laws are constantly changing. There's going to be a big change, as you know, in 2025 with the change of the estate tax numbers and this kind of thing. So what I want to tell everybody out there is that make sure that you know that everything is right. It doesn't cost you anything to talk to us. And if we determine that it makes sense for you to move forward, you're paying a much discounted price from what you might pay out there on the street.
Yeah, and all those changes and continuous complexities, I think, are the real value of having a team like Timewise and Cornerstone in your corner, per se. But that being said, one story I wanted to share on what you were just talking about is I've experienced with a client who got those 3 documents in order, had the full financial power of attorney, all of that jazz. And then the client unfortunately got dementia. And so they were getting it set up with another account that had kind of slipped through the cracks. And the financial institution was like, well, we need her to sign for this, to us add this power of attorney. Well, she's legally incompetent. She's unable to make that adjustment, So by not ensuring that all the, I guess, ducks were in a row, it created a real tough situation once she was unable to sign. So that being said, so I think a lot of people just think of trust for money, cash that they want to leave to their heirs. What all sorts of assets can be placed into a trust? And for some of the less liquid assets like cars or family heirlooms, what's the benefit of putting them in the trust?
Well, obviously, anything that goes into the trust passes to the intended beneficiary without the need for probate. So one of the things that you need to do is people need to understand the difference between qualified money and non-qualified money. So, and I don't need to tell you this, but qualified money are things like IRAs and 401ks and TSPs and things like that. Those are retirement in nature typically. So those don't typically go into a trust when you establish a trust. Now they typically will go in at your death, so that if an intended beneficiary was embroiled in a legal action, let's say, you wouldn't want your IRA to go immediately to that daughter that's maybe been in a car accident that was her fault and she's being sued. So we want to protect that. So we wash it through or have it filter through the trust first. So there's some advantages to doing that. But everything else, checking account, savings account, real estate, your personal effects, automobiles in some cases, if there's no note on the automobile, those kind of things go into the trust now. And remember, there's no downside. So because you are the trustee, you just simply now, when you buy or sell, you're simply buying or selling as a trustee of your own trust. One of the disadvantages I think that people will try to do is they're like, well, I don't want to spend some money to do this. I'll just put my kid's name on all my stuff while I'm alive. Well, that can be a nightmare situation. Number
Mhm.
one, when you do that, if you ever want to sell that asset, you need the kid's permission to do it. If that kid were to get into a legal action, a lawsuit or divorce or bankruptcy, well, now your stuff could be embroiled in that. And then there's huge tax consequences like that, no stepped up basis. And those are things that you can explain to your people. But I think that most people, if they would sit down and look at this, if they said, well, I can get this done now and give me peace of mind and protect my kids, most of the people, in fact, all the people that we've helped you with have
Mhm.
all said that when we've left. This was a huge weight off of my mind, gives me peace of mind. And that's what we do.
And so let's say you are driving here in Woodstock on Highway 92, and I don't know, your daughter texts you, and you look down real quick and look up, and you just lightly tap a car at about 3 miles an hour. And then the driver of the car in front of you gets out, and they're laying in the floor screaming, their neck hurts, their back hurts, they need a fusion surgery, all this jazz. Would a trust protect you while you're still living in that scenario at all?
Well, first of all, don't tell them you have a trust at that point. What I would do is I would say, oh, let me call 911. Don't say anything to anybody and call a lawyer. But to answer your questions, trusts do offer various degrees of protection. But the reason that you do a trust is not for that typically. The real reason is I want to make it easier for my heirs to get what I've worked for my whole life. I don't want the government involved in my family business. I want it to go directly to the kids. That would be, in my opinion, a better use.
Awesome. And then last question. So,
Oh, and don't text and drive.
oh, so last question is, all right, let's say I passed, and let's say my kids don't get along too well, and I named one of them the executor of my trust, or said both of them are the executors of my trust and responsible for making sure what I wrote out happens. But when I'm gone, I can't be there to mediate that conversation. How does the trust ensure, or who ensures that what's in the trust is what actually happens?
That's a great question. So whoever you appoint as the successor trustee, which is kind of like an executor. So I'll just use my case. I've got 4 kids, right? Anytime you try to get 4 people together to decide anything, it's difficult. The trust is what we call revocable or tweakable while my wife and I are alive. We can make these changes to it. But once we die, the trust becomes irrevocable. All right. So whoever we appointed as our successor trustee is bound to carry out the terms of the trust, and they are now a fiduciary. So in my case, or in my wife and I's case, we named our oldest child as the successor trustee, kind of like the executor. Now, all 4 of them are equal heirs to the trust. 25% of our estate is going to go to them. Our trust is pretty simple. It says sell everything and split it 4 ways after you've covered the costs of our passing and that kind of stuff, right? So that our son is bound to do that. And we trust our son to be able to do that. But if he was incapacitated or if he predeceased us, we named our daughter as the backup. And then we named our other daughter as the backup. And then because we have 4, we named our 4th daughter as the backup to the backup to the backup, right? At the end of the day, if our oldest son tried to abscond with everything, each of our kids actually has a copy of our trust. So if they tried to abscond with everything, then the children would then file a lawsuit in court to remove him as the successor trustee for cause.
Mhm.
Now, again, I've been involved with thousands and thousands of estate plans. I've only seen one case where that's actually happened. most of the time people are saying, I trust my kids, or there's at least a member of my family that I trust to do this, and I'm going to empower them to do it. They trust them way more than they trust a judge or a lawyer or something to do this. Does that make sense?
Oh yeah, for sure.
Yeah.
Oh, well, before we get to questions and answers, I just want to highlight one. I think everybody needs to build out a financial plan for themselves. Otherwise, I wouldn't be in this industry. And so after hearing this, if you're interested in fine-tuning your financial plan, if you've got questions about your taxes, your investments, your potential retirement success, or anything along those lines, we encourage you to give us a shout. Our contact info will be up shortly. And you'll see part of the benefit of working with us is you get connected to people like Mike, who we know enough to get to notate that, hey, you might have a shortcoming in your estate plan, but Mike is the one who sees it to the end and at a preferential price for all of our clients. So we'll hope you guys can either scan the QR code, shoot either of us an email, or give us a shout if you have any questions you don't want to ask on screen in the chat, or if you just want to learn more. But that being said, now's the time, if you have any questions, to go ahead, and there should be a chat function at the bottom of your screen that you can type out that question, and we'll take a few minutes to answer them. Out of respect for everybody's time, we'll wrap up shortly, but if you have a follow-up question or we don't have time to get to yours, please do not hesitate to reach out. In the next couple of business days, we'll get you an answer. So that being said, Kimani, has there been any questions posed?
Yes, so we do have a question, and this would be to Mike. Do you have legal connections in Arizona?
Interesting that you say that. Yes. I've got attorneys that I work with in Arizona, and that's a good question too, because depending on where you live, one of the advantages of a trust, let's say you own property in Arizona, but you now reside in Georgia, you would want to set up a Georgia trust and then redeed your Arizona property into your Georgia trust, and that eliminates probate in both states. So the answer is yes. And I always tell this laughingly to everybody. If you have property or anything in Hawaii, I will personally go out there and help. It may take me about 3 or 4 months to solve your problems, but I will work at it diligently.
Yes. And your wife can go out there as your assistant because she
Yeah,
is
absolutely,
needed.
absolutely.
And one more question for you. Is it possible that if you just have a will in place, could that potentially leave a chance for beneficiaries to have to deal with probate court? Like, could that leave holes just having a will in place?
I think the answer is yes, because let me give you some examples. If you just have a will, but you own a house, dead people can't own stuff, so a judge has got to sign off on that, hence the probate process. In Georgia, you can't beneficiary your real estate to anybody. On bank accounts, I can have my child as my beneficiary, which I should, but if that beneficiary predeceases me, now I've got another problem. I would need to add another beneficiary, whereas if you had a trust, you would make the trust the beneficiary, because at the end of the day, when everything goes to the trust, it'll be distributed to your heirs based on your wishes.
And we have clients that are here in Georgia, as well as Colorado and some other states across the country. Are a lot of the rules that you've mentioned, are they applicable like across state lines? A lot of them, are they very similar?
Well, first of all, I want to say this to my Colorado people. That's my home state. I'm a fifth generation Coloradoan. I come back out to Denver, and my dad taught us to ski when we were 5 years old, but I live in Georgia now, but I come out to Colorado all the time. So hello to all of my Colorado people. The answer is typically there is some similarities between states. So for instance, wills are recognized as sovereign. So if you have a will in Colorado and you move to Georgia, there's a very good chance that the courts won't recognize that in Georgia. Now, it's not 100%, and that's the thing that people have to understand about the law. We don't know if a North Carolina power of attorney is going to work in California. Unfortunately, when you do find that out, it may be too late. So trusts are under the Uniform Trust Act are across the country, they're accepted. But the other documents, the ancillary documents, powers of attorney, state specific, I've got attorneys everywhere to be able to help people with those. So the answer is, I know this is not what people want to hear, but the answer is maybe.
Very
Maybe.
well.
All
Well,
right. We
Mike,
just
thank
had
you.
one more question come in really quickly. Does a trust pass your assets without taxes, i.e., your home, the amount of money that you have in your bank account, etc.?
So typically, and Matt can speak to this even better than I can, but revocable living trusts are tax neutral. And what that means is there's no advantage tax-wise and there's no disadvantage tax-wise. So on a revocable living trust, it's done under your social security number. So, interest that you pay on your house is still deducted on your income tax return. And unless your estate is exceeding about 12.1 million per person, or with a husband and wife, 24.2, or whatever the exact number is, then it's a non-issue. So again, I would talk to Matt about that or your CPA, but basically trusts or living trusts are tax neutral.
All
Awesome.
right. Awesome. Thank you so much. We're so thankful that you guys were able to join us today. That contact slide was up on the screen. And so if we haven't had any conversations with you, we would love to get to know you. And for our current clients, thank you so much for joining us. If you would want for us to help you get in touch with Mike, we will definitely do that. Just send a request to your financial advisor. And we'd also love for you guys to tell us what kind of education that you'd like to see. What kind of webinars would you like to see? Because we definitely want to cater our content to what's important to you guys. So thank you so much, Mike, and thank you, Matt. This was a great conversation about estates and trust, and I trust that everyone has learned a lot.